When can a tenant legally hold back rent? My name is Yashbir Kudal and I am a real estate lawyer at Capital Law. Here's what you need to know about withholding rent in Ontario. In most situations, a tenant is required to pay their rent in full and on time, even if there are serious issues with the unit, such as repairs not being done or essential services not working. Withholding rent without following the correct legal process can result in a tenant being at the risk of eviction. That being said, tenants do have options. If a landlord is failing to maintain a unit in a good state of repair, the tenant can file a T6 application with the Landlord and Tenant Board. A T6 application gives the tenant an opportunity to explain any issues with the unit and to ask the board for assistance. If the board agrees, they can order the landlord to make repairs, reduce the rent for a specified period of time, or order the landlord to pay the tenant compensation. However, it is important to understand that this is only possible once the board has reviewed the situation and made a decision. Even in cases where a legitimate issue does exist within the unit, a tenant cannot withhold rent without following the correct legal channels first. There are very limited situations where withholding rent may be permitted. Even then, it is usually because the Landlord and Tenant Board has already issued an order or given permission in a specific case. In most cases, if a tenant withholds rent without going through the correct legal channels first, the landlord may be in a position to issue a notice of eviction for non-payment of rent. Even if there are serious issues with the unit, there is a legal process that must be followed. Withholding rent without following the correct legal steps can often make the situation more difficult. If you are a landlord or tenant dealing with a rent dispute and require assistance, please reach out to our office. Our contact information can be found in our bio.